So while the court takes a break, we can bring in trial attorney Jamie White, who is joining us from Michigan. Jamie, okay, let's talk about this cross-examination, taking a break. You know, I want to talk about you, your practice. You have a broad practice. You've dealt with hit and runs here. The way the state charged this, they charged her with second-degree reckless homicide. They didn't charge her with first-degree reckless homicide because the hurdle, of course, would be a lot higher for the state, the burden for the state. What's your take on the way they charged this case, and is the state doing a good job proving its case?
So I'll take the second question first, if you don't mind. You know, the prosecution, in my opinion, is completely off the mark here, in the sense that they're really creating a basis for the jury to have reasonable doubt as to whether or not there was any knowledge or, more importantly, intent as far as the hit and run. There's no allegation that this was an intentional homicide. You know, the allegation is that the accident happened and that she fled and lied and covered it up. And I just don't see that they're going in that direction. Quite frankly, to the opposite, I see that the prosecution is you know, they're hurting their own case by creating an environment where I think reasonable people could agree that in a state of Wisconsin in the winter, there's alcohol involved. You know, did she know that she had hit her husband? You know, that is the ultimate question here. I don't think anybody's alleging that she intentionally hit him, which goes to your first question, and that is, you know, are we at the highest level of culpability? And that is, you know, you're out there, you knew you hit somebody, bam, you leave, and so on. And I think the prosecution is digging their own grave.
You know, Jamie, yesterday when she was on direct examination, she mentioned something I didn't know about in this case. She said the light was on in the truck. So you have this big Dodge Ram pickup truck, snowing, Wisconsin, freezing cold. Light is on in the truck. So she was saying that she couldn't really see. And then she even said, her counsel asked her, if you had struck him, would you have stopped? And she said, yes, I would have stopped to help him. That was on direct examination. I thought when she said that, she came across extremely credible. Any thoughts on that kind of testimony in a case like this?
I agree, and I would even add, Kelly, that when she provided that testimony, she indicated the light was on because the door was open. You know, so there's this frantic fleeing of the scene with the light on, and anybody that's from the Midwest will understand that in a snowy environment with lights and a door open in your truck where you're fleeing an assaultive individual, and in this case her deceased husband, unfortunately, it definitely creates the atmosphere for not knowing what you're running into. I can tell you, being from Michigan myself, you know, simply running into something in the winter in a frantic state, you would not imagine that it necessarily was a person. You know, is there some negligence here and some arguments that the prosecutor can make? I suspect there are, but the idea that a person in Wisconsin in a snowy environment can run into a snowbank or what they believe to be a snowbank with the lights on at nighttime and not know they hit a person, that is reasonable. That is certainly reasonable doubt.
Yeah.